I got a really nice email yesterday from one of you lovely viewers, just saying that they'd found these videos rather helpful in a claim that they'd brought. They did mention, however, that they had some issues putting the bundles together. So what I thought I'd do today is I would actually explain what a bundle is, how you put it together, and also a little bit of humour. I'm going to introduce you to what we call Sedley's laws of documents, which is, I think, a very good way of addressing all the issues about bundles. So stick around, this does get funny. Not from me, I'm quoting somebody a lot funnier. And also some practical advice on how to prepare bundles in a way that makes the judge's job easier. And as I always say, if you want to succeed in a legal claim or an application, making the judge's job easier is a really good way of starting. Okay, so what's a bundle? The bundle is just the collection of documents that you use in a hearing, whether that's a trial or an application. Now, what actually goes in the bundle, if you go to the White Book, which is the guidance to civil practice, or indeed just look at the civil procedure rules online, they will tell you what needs to go into bundles for particular applications. But it'll be things like, one thing that's always good to start with is just a chronology of events, because don't forget, a judge needs to understand very, very quickly what the issues are in this case. So a chronology setting out, it could be something like, on X date, I bought a car from this particular person, later on this fault occurred, on this date we took it back, then this happened, and eventually, after writing lots of letters on these dates, we hadn't got satisfaction, we couldn't agree everything, and therefore I issued the claim. Also, you can put in a dramatis personae. If there's quite a few people involved in a claim, just say at the beginning who everybody is. Mr. Joe Smith, he is the director of the claimant company. Mr. Fred Bloggs, he's the director of the defendant company. Things like that. But then you'll put things like, if you're preparing for a trial, you'll put things like the pleadings in, the particulars of claim, the defence, so the judge can see instantly, what the case is about. Then you might put in your skeleton arguments, for instance, or you might put your witness statements in. I mean, how you prepare the bundle is pretty much down to you, but the key thing to do is to make it as easy to understand as possible. Okay? Whose responsibility is it to prepare a bundle? Generally speaking, it's the claimant or the applicant. So if you bring a claim, then it'll be the claimant's job to prepare the bundle. If you're making an application, it'll be the applicant's job to prepare the bundle. But you will ask the other side and say, what documents do you want in this? Now, one thing to remember that catches some people out, anything that goes in the bundle without challenge is deemed to be accepted to be authentic. So say, for instance, you are saying, a letter is a forgery, a document is a forgery, although those emails have been tampered with or created after the fact, and you want to challenge that, you have to raise that before they go in the bundle. Because once they're in there, the judge is going to say, well, sorry, as far as I'm concerned, this is authentic. That does catch some people out. Even if you're just going for a short application, you just want more time to file a defence, or you're applying to set aside a judgment in default, putting the key documents in there. Another great thing to put in a bundle for an application is a draft order. Because I always say, tell the judge who you are, what you want, why you should get it. Well, if you put the draft order in, saying this is what we want the end result to be, well, that ticks the what you want box. But when it comes to preparing bundles, this is Sedley's Laws of Documents. The Right Honourable Lord Justice Sedley, a very, very senior judge, he just got so frustrated with the quality of bundles that he prepared this rather snarky document. Okay? So the first law, documents may be assembled in any order, provided it is not chronological, numerical or alphabetical. Second law, documents shall be in no circumstances be paginated continuously. Fourth law, every document shall carry at least 3 different page numbers in different places. Fifth law, any important documents shall be omitted. Sixth law, at least 10% of the documents shall appear more than once in the bundle. Seventh law, as many photocopies as practicable shall be illegible, truncated or cropped. Eighth law, at least 80% of the documents shall be irrelevant, but there's a subclause to that. Counsel shall refer in court to no more than 10% of the documents, but these may include as many irrelevant ones as counsel or solicitor deem appropriate. Ninth law, only one side of any double-sided document shall be reproduced. 10th law, transcriptions of manuscript documents shall bear as little relation as reasonably practicable to the original. And the 11th law, documents shall be held together in the absolute discretion of the solicitor assembling them by 1. A steel pin sharp enough to injure the reader. 2. A staple too short to penetrate the full thickness of the bundle. 3. Tape binding so stitched that the bundle cannot be fully opened. Or 4. A ring or arch binder so damaged that the two arcs cannot meet. I'll come back to this because this actually does illustrate some really good points about bundle preparation. People have added other laws as well. I mean, one I quite like is that if you want to highlight anything that's important in a document, you must do it in a highlighter that comes out black when you photocopy it, because that happens a lot. But this is very true about documents. I mean, like I say, you're trying to make the judge's job as easy as possible, so, as understandable as possible, and you're trying to present your case, to the best of your ability. And there's two things there. First of all, just general sloppiness. It just comes across badly, especially if you're going to be arguing something like, I'm a very competent person and, you can trust me and you can trust everything I say and I would get everything right. And it's like, we can't even get the bundles right, mate. But also it's just, if you copy a document and the ending is cut off and you can't read it. I mean, another one is people always say, when you do the hole punch thing, put it sort of like no more than 1/4 millimetre away from the edge, the hole from the edge of the page, so that it eventually tears and they all fall out. But you use these laws. I mean, obviously don't, try to not abide by any of these laws. Try to do the opposite, because like I say, it's all about the presentation. Now, one thing that's very important is what needs to actually go in there. It is very tempting to throw the entire kitchen sink in there, and people will do that. They'll just get their file of papers, and it's like, right, everything needs to go in, crunch, crunch, crunch. And this is a big problem now with emails, because you'll be reading an email chain, and because of the way that quite often emails print out and they're all nested, everything's below it. So it's like, here's one email, yeah, that's fine, but then you'll sort of do the response email, but that will still have the original one underneath it because of the way they work, and then you put the next one, and that will have the reply to the reply plus the original thing, and it just snowballs forever. And it can be a nightmare working out, the chronology on that. So, if you've got to put an email chain in, think how you're going to do it. Are you actually just going to do one big nested one, the final version? This is all the emails in one thing. Or will you just separate them out? So this is the email we sent. This is the reply we got to that email. This is the next email we sent. So there's just that email there. And use indexes and tables. Set out. I mean, it is always very tempting to sort of go, page 1, the pleadings. Page 10, the witness statements. Page 97, the evidence. But maybe just make it a bit easier. Page 1, the particulars of claim. Page 7, the defence. Page 12, the reply. Page 47, the first witness statement of Joe Bloggs. Page 57, the second witness statement of Joe Bloggs. Make it as easy to find. Use tabs, because judges, will sometimes do this and say, well, actually, that's very, very, that's interesting, but what I want to see is, what's your point about this? Or, does anybody address this particular piece of evidence? And you need to be able to say, oh, yes, actually, that's dealt with in one of the witness statements. Your lordship will find it behind tabby at page 47 in bundle 3, something like that. But, you want to simplify it. So one thing we will quite often do is do a bundle and say, these are the core documents. These are the ones that we think you'll definitely have to look at. But I do a thing sometimes where I'll do a supplementary bundle and say, here's lots of other material in the case that actually we don't think is necessarily relevant. And you can agree with the other side on this and say, look, we'll send everything, but you'll send that as a bundle that's, here's some extra material that may become relevant, but, you know, and actually say, we wouldn't expect you to read it before the hearing, because it might not. But, you know, it's there if you need it. I mean, it's always a good idea. It's always better to, you know, have a document available that you don't need than not have a document available that you do need. But don't saturate the judge. So, like I say, using the core bundle thing, and this is what I say in the top tip to help win your case. If you've got a really simplified bundle and you say, that's the thing you actually need to read to understand the case, and here's loads of other stuff that hopefully won't become relevant, but, you know, if we get a surprise answer from a witness, or if your lordship suddenly spots a point that we hadn't considered, we can probably find the material in there. Yeah, so there you go. I mean, I'm hoping that has assisted you. And like I say, when it comes to preparing bundles, if you're bringing the claim or the application, it'll be your job to do it. There is an exception to that, actually. If one party is represented by lawyers and the other isn't, then usually the court will say, can the party that is represented prepare the bundles? But this is a joint effort. I mean, you know, there's meant to be one bundle for the entire hearing. Another thing that people quite often get wrong is, and especially in these days of PDFs, you know, is page numbering. Because you know, it used to be very common that the bundle, we'd do a witness bundle and say, you know, here's a bundle for whoever's like in the witness box at the current time. And that would have a different pagination to everybody else. And you'd be doing, this even happened, you notice this happened in the post office inquiry, where the witness bundles were about 11 pages out compared to the bundles that everybody else, the lawyers were using. So it was all, can you turn to page, well, hang on, in our bundle it's page 57, so in your bundle it's going to be page 68. A lot of things are done now just by PDF. The way to do that is to actually start the pagination. At page 1 is the first page in the bundle, even if that's just a cover page. You know, ironically, then you might actually end up with the index to the bundle being on page 2 or 3. But the idea is you should be instantly able to find it. The convention for page numbers, because quite often you'll be copying documents that had page numbers already on them. So I like to do it the real old school way, which is to get a big black marker pen out, and when we have finalised the actual bundle, and I will actually prepare it as paper quite often. I mean, it is always very tempting just to do it as PDFs and then automatically put page numbers on them. But I like to get the big thick marker out, and in the bottom right hand corner, 1 big circle around it, 2 big circle around it. You know, make it obvious that that's the page number that people need to be looking at. Although you will not be criticised if you put in a PDF document and it's just got the little tiny number that's been auto-generated. What courts have actually been asking now as well when you do PDF numbers is to actually hyperlink them, so that, you know, you click on the item in the index and that automatically takes you to the you know, to the relevant electronic page in the bundle. But yeah, I hope those tips are useful, because like anybody involved in any sort of court proceedings, chances are there's at least a 50% chance it'll be your responsibility to prepare the bundle. But you also need to, even if somebody else is preparing the bundle, you know, you need to be able to approve it. So you know, you need to understand as well. And don't be afraid to go back and say, I don't think this bundle is particularly helpful. I think we should put these documents in a supplementary bundle, or I think we should add this, or we should do, you know, put everything chronologically, or you might want to say put everything issue-based, or we might want to use tabs to separate these witness statements from these witness statements, something like that. Because obviously, when it ends up in front of the judge, if the judge is going, this bundle's a nightmare, you know, sort of going, well, actually, they prepared it, and the judge is going to say, yeah, but you approved it. I mean, I mentioned before about the role of judicial assistants in, you know, the High Court and the Courts of Appeal. And a lot of their time is just spent trying to, you know, sort out terrible bundles. So that by the time, you know, the judge gets the bundle, at least it is actually usable. But don't forget, these judicial assistants, they talk to the judge and they'll be saying, I spent the last, like, 8 hours trying to put this bundle into some sort of order. You know, and again, you don't want the judge subconsciously thinking, right, you've made my job a lot harder, but also it reflects on you, even if it's through your lawyers. You know, and judges will try not to hold it against you just because your lawyers did something wrong. But like I say, you know, it never hurts to make the judge's life as easy as possible, and it certainly can hurt to make the judge's life difficult. So there you go, and thank you ever so much for that email. It meant a lot to me and Dan. So as always, hope you found that vaguely interesting, vaguely useful, vaguely accurate. As always, thank you for commenting on the Ramsey Hunt thing. I mean, I don't know what you think, but I think I'm sort of sounding a bit better. You know, I'm sort of getting the use of my face back, which is quite nice. Although I do like the fact that I can now currently do a really good Billy Idol type sneer. Ooh, that might be a good thumbnail. Hang on, I'll just move to one side. I like asymmetrical thumbnails. How's that? Bundle prep. What about bundles? I'm just trying to think of a catchy thumbnail title for this as well, because you know, it's not exactly the most sort of like exciting subject, is it? But like I say, it is one that crops up a lot.